date. Court registrar. Is the defense counsel aware?
Yes, my lord, the defense counsel is aware.
So why is he not here? What time did you tell him?
I told him 11.
So you need to call him back and let him know that you are not the time.
I've called him before.
Call him again quickly. Let me give you just about 2 minutes to do that. Mr. Oga, let's hold on a bit for the court registrar to tell Mr. Ajewale about the change in time. I didn't know I would finish my normal court sitting earlier than envisaged.
No, I
Divisional Registrar Lokoja, do you have Leonard Defense Counsel's number?
Yes, my lord, I have it. I've called them, my lord.
You've called him?
Yes, my lord.
That we have changed at the time. So what did he say?
Yes, my lord. He said they will get connected now.
Call him back to let him know that I'm waiting.
Yes, my Lord.
Lokoja got in touch with him. Have you responded, Lokoja?
Yes, my Lord. Yes, my Lord.
Is he connecting? Call the case. Lokoja, call the case. Registrar Lokoja, call the case. If the Lokoja registrar on seat, let her call the case. If not, I will ask Abuja to call the case.
Okay, my Lord. Call the case.
Case number NICN LKJ 14/2019 between Edward Egwabu Edward Okwibile and Kogi State University, Ayimba, and two others.
Who are the two others? Who are the two others? Call the names of the two others.
Sorry, my Lord, I don't have
The governing council, Kogi State University. The registrar, Kogi State University. Is there any of the parties in court?
No, my Lord.
Parties absent.
Appearances.
Respectfully, my Lord, I am EU Oga, sir. EU initials, Oga OGAH, sir. My humble
Therefore,
appearance is for the plaintiff, sir.
we call that claimant in court, in this court, claimant.
For the claimant, sir. My humble appearance for the claimant, sir.
Very well. Any other appearance?
No appearance on my side, sir.
Here is the judgment of the court. The grievance of the claimant for approaching this court is that his employment was unlawfully terminated by the first defendant. According to him, he joined the first defendant via the letter of offer of appointment as an assistant lecturer, and his appointment was confirmed. Just a minute. He He avers that as a lecturer in the Department of Sociology, he performed his duty as expected and to the best of his ability, and that he neither had any issues with the department nor with the first defendant. He continues that on the 6th of February 2017, he had a little misunderstanding with his former fiancée, one Miss Solomon Maria Ometere, who was a former student of the first defendant and had graduated before the 2nd and 3rd of February 2017 industrial action embarked upon by the union of the first defendant, and that the said misunderstanding occurred in his house outside the premises of the first defendant, and equally it is a misunderstanding that can be said to be a domestic affair. He stated that on the 10th of September 2018, that is 21 months after he had a misunderstanding with his former fiancée, he received a query from the first defendant with respect to the misunderstanding that ensued between him and her, which happened on the 6th of February 2017, and was asked to explain why he should not be sanctioned. He stated further that he responded appropriately to the query and explained to the first defendant his relationship with the said Miss Solomon Maria Ometere, and further explained how the misunderstanding was amicably settled by the police and that he and his fiancée still maintains a good relationship till date. He stated that he received a letter dated 29th of October 2018 from the first defendant suspending him on the basis that his response to the query issued to him was not satisfactory, and was further asked to appear before the Senior Staff Disciplinary Committee on Monday, the 10th of December 2018, via the letter dated 7 December 2018. He obeyed and appeared before the committee. Consequently, he was waiting for the outcome. He was served with a termination of appointment letter dated 19th of December 2018. He thereafter followed the due process provided in the first defendant's condition and scheme of service for senior staff, which allows him to exercise his right of appeal, whilst waiting for response to his letter of appeal, but received none, following which he wrote a reminder, yet no response from the defendants, that he equally caused his solicitors to write a letter demanding for his recall to duty, and same was also neglected by the defendant. He contends that he has been unfairly treated, and the termination of his appointment was a sheer malice. It is consequent upon all the above that the claimant, by a complaint dated the 5th of April 2019, commenced this suit against the defendants, praying the court for the following reliefs. 1. A declaration that the termination of the claimant's appointment by the defendants via the letter dated 19 December 2018 is a violation of the first defendant's condition and schemes of service for senior staff. It is therefore invalid, null, void, and of no effect whatsoever. 2. A declaration that the termination of the claimant's appointment by the defendants via its letter dated 19 December 2018 is a violation of a plaintiff or claimant's right to fair hearing as enshrined in Section 36 of the Constitution of Federal Republic of Nigeria 1999 as amended, and it is therefore invalid, null, void, and of no effect. 3. A declaration that the claimant is still in lawful employment of the first defendant. 4. An order of this honorable court setting aside the decision of the defendants as contained in its letter dated 19 December 2018. 5. An order of this honorable court reinstating the claimant to his office and position as lecturer 2 in the first defendant. 6. An order of this honorable court deeming the claimant has already been promoted to the office and position of lecturer 1, as same promotion shall be due in October this year, 2019. 7. An order of this honorable court directing the defendants to pay all the entitlements of the claimant from the date of suspension to the purported termination of his appointment until judgment is delivered. 8. An order awarding the sum of 100 million naira as general damages for the humiliation and embarrassment suffered by the claimant as a result of the unjust termination of his employment. And 9 is the cause of litigation, which he puts at 200,000 naira only. The defendants, in their response filed on the 24th of May 2019, admits that the claimant was an assistant lecturer in the Department of Sociology in the employment of the defendant. They, however, deny that termination of his employment was unlawful. They assert that claimant's appointment was subject to the provisions of the university laws, statutes, and ordinances made thereunder, and to the conditions governing the appointment of senior staff made by the first defendant counsel from time to time, and equally that the appointment was for a probationary period of 2 years from the date of assumption of duty, thereafter confirmed, but that the said confirmation was threatened at the time due to the conduct of the claimant. According to the defendant, barely 6 months into the claimant's appointment, he started having problems bordering on misconduct involving assault of 2 female and other students, consequent upon which an administrative query was served on him by the acting head of the Department of Sociology, one Dr. S.U. Udoma. Also, that the relationship of the claimant with his fellow staff became so bad that the said acting head of Department of Sociology withdrew his endorsement of confirmation of appointment of the claimant. Yet the claimant failed to show remorsefulness for his misconduct, and a warning letter was served on him dated the 16th of July 2015. One Dr. Toyin Adefolaju, a visiting lecturer to the Department of Sociology of the first defendant, was equally not spared of insults by the claimant, and that the alleged act of misconduct by the claimant remained unabated, consequent upon which the head Department of Sociology of the first defendant had to report the claimant to the Vice Chancellor of the first defendant. That on the 16th of June 2016, claimant disrupted the meeting of ASU executive of the first defendant on the ground that he was not invited and series of other misconduct. The claimant on the 12th of October 2016 wrote a letter of apology to the Dean, Faculty of Social Sciences of the first defendant, wherein he apologized for his past behavior and promised to be of good behavior. However, in spite of the apology and undertaking, claimant was allegedly accosted by the officers of Nigerian Police Force, Ayingba, following an allegation that he assaulted one Ms. Solomon Maria Ometere, a 400-level student of political science of the first defendant, wherein the security unit of the first defendant investigated the matter and found the claimant culpable, consequent upon which the claimant was issued a query, and his response to the said having not been satisfactory, he was placed on suspension. Thereafter, the claimant was referred to the Senior Staff Disciplinary Committee in accordance with the condition of his employment. Subsequently, on the 13th regular meeting, of the SSDC, his case was discussed and that of others, and accorded him opportunity to defend himself. Following the unsatisfactory defense of the claimant, the SSDC recommended that the appointment of the claimant with the first defendant be terminated, and this was approved by the governing council, consequent upon which the appointment of the claimant with the first defendant was terminated on the 19th of December 2018. The defendant stressed that the termination of the claimant appointment is in accordance with the conditions and schemes of service for senior staff of the first defendant. The defendant finally prayed the court to dismiss the claimant's claim as being frivolous and vexatious. Parties during trial urged the court to invoke the provisions of Order 38 through 33 of the rules of this court to allow them argue their case on record, and the court on the 16th November 2020 granted the prayers of the parties. As it is customary to do in this respect, parties filed their respective written addresses with the claimant filing first on the 22nd of December 2020. Counsel raised a sole issue, and I have reduced that into the body of this judgment. The defense equally filed, and they also framed issues which have been reduced into the body of the judgment. I will now go straight to the decision of the court. Claimant equally filed a reply to the final written address of the defense. A careful perusal of all the processes filed before the court showed that in order to have a just determination of the issues raised by parties, these two issues are to be considered. These, whether or not the claimant employment was unlawfully terminated, and 2, whether or not the claimant is entitled to the relief sought. It is germane at the onset to deal with some pecuniary issues raised by the defendants. It is the contention of learned defense counsel that Order 3, Rule 1 of the rules of this court makes provision for initiation of civil proceeding before this court. He went on to state that the claim of the claimant does not come by any of the ways in Order 3, Rule 1 of the rules of this court, and that the claimant cannot hide under the omnibus provision of Order 3, Rule 1, Sub-Rule 1G, as there is no other means prescribed by these rules or known act or law in force in Nigeria that allows proceedings to be commenced by writ simpliciter. The closest to this, according to him, is the writ of summons, which is not the route through which the claimant has come before this court. He equally submits that the word, quote and unquote, may in Order 3, Rule 1.1 does not leave the route to the court at large. Rather, it merely provides choices. Counsel further proceeded that the law is right, that where a law or rule prescribes a method of commencement of a particular type of proceeding, where such proceeding is wrongly commenced, it will not be treated as a mere irregularity, as envisaged in Order 5, Rule 1 of the rules of this court, but should be set aside. He further submits that this suit, having not been instituted in consonance with the rules of this court, the action is not initiated by due process of law, and consequently, this court lacks jurisdiction to entertain same. Claimant counsel, in his response, proceeded that while preparing the complaint, made a typographical error by imputing the word, quote and unquote, read, where the word, quote and unquote, complaint was meant to appear. That the above error of the claimant counsel does not invalidate the entire process to set it aside and rob the court of jurisdiction. Rather, it can be treated as mere irregularity. He cited Order 5, Rule 1 of the rules of this court. Continuing, he equally submits that it is straight law and general practice of court not to punish litigants for the mistake of his counsel. Now, a cursory look at the originating process filed by the claimant on the face of it clearly shows that it is an originating process, though not titled complaint per se. It is titled, quote unquote, writ. Even though the claimant wrote writ simpliciter, it is apparent that it is writ of summons used in the commencement of an action. By Order 1, Rule 1, Sub-Rule 1 of the rules of this court, it provides that, I quote, where a matter arises for which no provision or adequate provisions are made in this rule, the court may adopt and apply any procedure as it will, in its view, do substantial justice to any of the parties concerned in the matter, unquote. While Sub-Rule 3 of Order 1, Rule 9 provides thus, and I quote, the court may disregard any technical irregularity which is likely to result in a miscarriage of justice, unquote. It is apparent from these provisions that this court is at liberty in the interest of justice to allow any party to approach the court by any means as provided for under the rules of any other court. It is notorious that the writ of summons is the means of commencement of an action in civil causes and matters. It is thus obvious that the word, quote and unquote, writ, written on the claimant's originating process is a means of commencement of an action. The content of the process filed evinces that it complies with Form 1 of the rules of this court, which is a format of a complaint in this court. It has all the features of a complaint. Memorandum was subscribed. It has the endorsement of the relief sought by the claimant. The register of this court signed on it. It was signed by counsel who took out the writ, 1 EU Auga Esquire. It is so clear as crystal that the claimant's originating process complies substantially with Form 1 of the rules of this court. Filed also is a statement of fact which forms part of the originating processes recognized by the rules of this court. It is therefore in the overall interest of justice of this case, as the court is enjoined to do, that I find and hold that the originating process filed by the claimant is competent. It is also plain on the document as argued by learned claimant counsel that it was a mistake on his part. The law as rightly espoused by counsel is that a mistake or sin of counsel should not be visited on his client, and to shut the claimant out from the hearing of the case on the merits is to hold him personally responsible for the negligence of his counsel. See the case of Doherty and Doherty, citation is provided. The case of Amadu versus Saulawa, citation is provided. The case of Bowaje versus Adediwura, citation is equally provided. It is in the light of all the above reasons that I invoke also the provision of Order 5, Rules 1 and 3, and treat this as a mere irregularity and hold that the originating process filed by the claimant is competent before this court and thus invokes the jurisdiction of the court to adjudicate on same. I so hold. In another vein, Learned Defense Counsel contends that the witness statement of the claimant in this case is devoid of oath, stating that it is the swearing or declaration that constitutes the oath, and the oath gives validity to the position. Responding, claimant counsel argued that the omission of the last paragraph of the witness statement on oath is an irregularity and therefore cannot invalidate the proceeding in the court or render inadmissible the evidence of the claimant, and it shall not be construed to affect the liability of the claimant as a sole witness to state the truth. Now, Order 3, Rule 9 of the rules of this court requires that a complaint be accompanied by witness statement on oath, and it is in compliance of this rule that the claimant files same. The law is also settled that for any deposition to be competent for use, it must be duly signed and sworn before the appropriate officer in accordance with the Evidence Act and Oath Act. Oath Act Cap 01, Laws of Federation 2004. The law is right that where a form is prescribed by an enactment, a form which differs from the prescribed form shall not be invalid for the purpose of the enactment by reason only of the difference. If the difference is not in material particular and is not calculated to mislead, see the case of Abga versus Dantong and others. Citation is provided. It is right that the law does not require a deponent to use the exact words in Oath Act, as anything used in substantial compliance with the requirement of that act will be enough in this era of substantial justice. See the case of Ojibara and others versus Governor of Kwara State, and another citation is provided. The case of Ogwebu versus Angomwa, citation is also provided. It is equally right that the appearance of stamp and signature of Commissioner for Oath raises a presumption of regularity. Applying the above decisions to the present case, it is quite clear that it is difficult to lay down a totally rigid general principle on the point, and that each case shall depend on its peculiar facts. Where there is a total non-compliance with the Oath Act, such oaths are defective, but whereas in this case, there is a substantial compliance with the Oath Act, it cannot be said to be defective. It is crystal clear from a careful perusal of the witness statement of the claimant that the opening paragraph states that it is an oath which is rightly so as in commencement of an oath. It is equally clear on the face of the document that it was deposed to before a commissioner for oath of this court, one Oruma Ayuba Musa, whose stamp and signature was affixed on the oath. This is in compliance with sections 1 and 4 of the Oath Act. Section 4, subsection 2 of the Oath Act specifically states that, and I quote, "No irregularity in the form in which an oath or affirmation is administered or taken shall be invalidate proceedings in any court," unquote. I am therefore persuaded by the submission of Learned Claimants Counsel that the objection of the defendants was nothing but a resort to technicality. Courts have long moved away from the domain or terrain of technicality to doing substantial justice. Accordingly, I discountenance the objection of Learned Defense Counsel on these two grounds for lacking in merit. It is the further grounds of the Learned Defense Counsel, vide paragraph 35 of the adjoint statement of defense, that claimant's suit is statute barred, having been brought outside the specified period of 3 months as stipulated by Section 3 of the Public Officers Protection Act, also known as POPA. That a cause of action arose on the 19th of December 2018 when the claimant's appointment with the first defendant was terminated, and he commenced this suit on the 5th of April 2019, about 3 months, 16 days which is not contemplated by the Public Officers Protection Act. The claimant, on the other hand, submitted as Section 3 of POPA, has not caught up with his case. He also stated that the cause of action in this case accrued and became enforceable after the condition precedent as required by Section 6.8 of Kogi State University Anyigba Condition and Schemes of Service for Senior Staff 2008 are met and exhausted. And in the instant case, it's a reply to his solicitor's letter dated 22nd of March 2019. Paragraph 2 of the above mentioned letter reproduced herein before VIX, I quote, "I write to acknowledge receipt of your letter under reference above and to inform you that there are no new information that will enable the university to rescind its earlier decision on your client, Mr. Egwu Abbas matter. Hence, the determination of his appointment from Kogi State University subsists, please," unquote. Now, a court is said to be competent and has jurisdictional power over a case or matter when the court is properly constituted as regards numbers and qualification of the members of the bench, and no member is disqualified for one reason or the other. The subject matter of the case is within its jurisdiction, and there is no feature in the case which prevents the court from exercising its jurisdiction, and the case comes before the court initiated by due process of law and upon fulfillment of any condition precedent to the exercise of the jurisdiction. All the requirements must coexist conjunctively before jurisdiction can be exercised by the court. It therefore means that where a court has no jurisdiction to hear and determine a case, but goes ahead to do so, it becomes an exercise in futility, as the decision arrived at in such a case amounts in law to a nullity, irrespective of how well the proceeding was conducted. That is the position of the court in the Locus Classicus case of Madukolo and Ikemdili. Citation is provided. See also the case of Umana versus Atta. Citation is provided. The case of Enterprise Bank Limited versus Aroso. Citation is provided. When a court is faced with issues bordering on jurisdiction or its competence, or whether or not an action is settled bad, all that the court need do is to consider the writ of summons and the statement of facts to see when the cause of action accrued vis-a-vis the date of filing the suit. See the case of Agi versus Eno. Citation is provided. The case of AG Enugu State and Ugu and another citation is also provided. It is necessary to also determine in the process when the cause of action in the case arose. A cause of action, as the law is right, is a series of facts giving rise to the cause of complaint by a plaintiff or claimant, and it accrues on the date in which the incident giving rise to the cause of action arose. The statute of limitation begins to run from the moment the cause of action arose. The claimant, from a perusal of his statement of facts and the complaint file, show that the cause of action in this suit, read paragraph 23 of the statement of facts, arose on the 19th of December 2018. However, by conditions and schemes of service, the claimant has the right of appeal, where is dissatisfied, read section 6.7 of the Kogi State University Condition and Scheme of Service of Senior Staff, and the said reply was responded to by the defendants via the letter dated 22nd of March 2019. Section 6.8 of the said Condition of Service provides, and I quote, clause 6.7, I first of all will quote clause 6.7, which is on appeal, and it states thus, I quote, "A staff who is dissatisfied with any disciplinary action taken against him or her shall have a right to appeal to the Vice Chancellor, and if still dissatisfied, then to the University Council. The appeal shall normally be made through the Registrar and Secretary to Council," unquote. Clause 6.8 states thus, and I quote, "No staff shall resort to law court without exhausting the internal avenues for settling disputes or grievances or seeking redress in the university. A breach of this provision is punishable by summary dismissal," unquote. It is evident from the above provisions that a staff who is dissatisfied with any disciplinary action taken against him or her, will have a right under its contract to appeal against any disciplinary action taken. It is obvious that the claimant, though sacked, he still has the right to right under his condition of service to appeal the decision of his employer, failing which he can approach the court. A staff who has written a letter of appeal will have an expectation either to receive a favorable or unfavorable response, but until he receives a response to his appeal, he will not quite be sure of his status. He will therefore be deemed to still be a staff of the first defendant until he or she receives a response from the first defendant. Clause 6.8 of the contract also urges staff to exhaust internal avenues for settling grievances or seek redress in the university before approaching the court. A combined effect of clauses 6.7 and 6.8 is that if staff of the first defendant has a window of appealing to the university for a redress before approaching the court. This is a right donated by the terms and conditions of his contract of employment. The claimant in this case exercises his right under the contract by writing letters of appeal on the 8th and 27th of January 2019 to the first defendant seeking a redress, but received no response. His solicitors wrote another letter subsequently on the 20th of February 2019, and that was upon which the defendant responded. If it is not important and germane as of right for an employee of the defendant to file an appeal to the action of the first defendant before approaching the court as in clause 6.8 of the contract of his employment, it will not have formed part of their terms of contract. That provision is thus binding on the claimant and the first defendant. It must thus be obeyed by parties to the contract and be construed by the court. The law is that a cause of action matures or arises on the date or from the time when the breach of any duty or act occurs, which warrants the person thereby injured or the victim who is adversely affected by such breach to take a court action in assertion or protection of his legal right that has been breached. I find from the facts and circumstances of this case that the first defendant breached his duty of responding to claimant's letters of appeal either way, which is an explicit requirement under their terms of contract, thereby warranting the filing of this suit by the claimant. It is in the light of this that I find that the cause of action in this suit accrued upon the refusal or failure upon the untimely response of the first defendant to the claimant's appeal letter. It does not lie in the mouth of a defendant who failed to comply with the said clause granting its staff the right of appeal to turn around at this stage, raising it as a shield in their favor and as a sword against the claimant. This case was filed on the 5th of April 2019, about 17 days after claimant's employment was terminated by the defendant. I find it preposterous of the first defendant who has breached his own contract to raise such an issue. The law is that he who comes to equity must come with clean hands. The first defendant, I find, has his hands tainted and soiled. If I may ask, what is the purport of limitation laws like POPA? The Court of Appeal in the case of CFAS Nigeria Limited and others versus MIG4 Nigeria Limited and another citation is provided. Consider the main purport of limitation law, which according to learned jurist Oseji JCA, now JSC, who read the lead judgment, he stated thus, and I quote, I think it is necessary to state from the onset that the purpose of any limitation enactment is to discourage and or stamp out stale claims arising from the lethargy of the claimant whose inactivity will have caused evidence in the case to disappear or create lapse of memory of the witnesses in the case with the passage of time, thus placing the opponent on disadvantage in meeting the case in court, unquote. Taking a cue from the above reasoning, will it then be right in the circumstances of this case to find that the claimant was lethargic or was inactive or went on his frolic in exercises his right under the contract? My answer is in the negative. This is in view of the facts alluded supra. It is in view of the circumstances of this case and all the reasoning herein before that I find and hold that claimant case is not caught up by Section 2 of POPA. Assuming, but I'm not conceding, that above position of the court is wrong. The law is now settled that there are exceptions to the limitation law, and it includes claim being founded on simple contract. The claims of the claimant herein is based on an alleged breach of contract by the first defendant. See the case law authorities of National Revenue Mobilization, Allocation and Fiscal Commission versus Johnson and others supra. The case of Ogier and others versus Cross River State Council on privatization, and another citation is provided. It is in the light of this position of the law and all the reason herein that I find and hold that claimant's case is not cut off by Section 3 of COPA. Accordingly, claimant's suit is competent before this court. I so find and hold. Regarding the cross of this case, it is a claimant's claim that the termination of his appointment via the letter dated 19 December 2018 is a violation of the first defendant's condition and scheme of service for senior staff, and that it is equally the violation of his right to fair hearing as enshrined in Section 36 of the Constitution of Nigeria as amended. It is therefore invalid, null, void, and of no effect whatsoever. The defendants, on the other hand, stated that due process of the law was followed, the precept of fair hearing was observed, and the laid down procedures of the university were complied with in the process that led to the termination of the claimant's appointment. It is important to state that there is no variance from the parties in the statutory nature of the employment of the claimant. An employment is said to have statutory flavor when the appointment is protected by statute or laid down regulations made to govern the procedure for employment and discipline of an employee. In other words, the employer must be a body set up by the Constitution or statute, and the statute or regulations made pursuant to the Constitution or principal statute or law must make provision regulating the employment of the staff of the category of the employee concerned, especially in matters of discipline. See the Locus Classicus case of Olani and University of Lagos citation is provided. The case of Imolame and YX citation is provided. The case of Oak Pension Limited and Michael Olainka citation is equally provided. The duty to construe an appointment with statutory flavor is the exclusive powers of the court, and in determining an employment governed by statute, and in this instance, the procedure laid down in the statute must be complied with, and the provisions of the applicable regulations and terms of appointment must also be followed to the letter, as any breach will render the exercise of termination null and void. That is the position of the courts in the case of Ojabo and Honorable Minister of Communications and other citation provided. The case of UMTHMB versus Dawa citation provided. The case of Mrs. Fakwade and OAU Teaching Hospital citation is equally provided. This procedure ensures that an employee is given fair hearing as enshrined by Section 36 of the Constitution as amended before terminating his employment, as it is settled that before an employer can dismiss or terminate the employment of its employee, the requirement of fair hearing must be strictly adhered to. Fair hearing is a constitutionally enshrined provision in the determination of the rights and obligation of persons. It provides for the opportunity that persons whose rights may be affected to make representation, it provides opportunity for persons whose rights may be affected to make representation to the administering authority before that authority makes decision affecting that person. It is a vital prerequisite. A breach of same touches on the root or foundation of the action or investigation, and thus will be declared a nullity by the court. See the case of Fale and others versus Dada and others citation provided. The case of Banke and 178 others versus Akure North local government citation is provided. It is founded on the three pillars of natural justice, which is embedded in the Mazim Audio Trem Patem, here the other side, and the Nemo Judas in Kasasua, you cannot be a judge in your own case. It means the affected person is given opportunity to defend himself by being given enough time to present his case. It means, in simplest terms, an opportunity to be heard. Say the case of Equazor and Union Bank of Nigeria citation provided. It is a contention of a claimant as per his release 1, 2, and 3, that the procedure followed by the defendants in terminating his appointment is unconstitutional, and negates the provision of Section 36 of the Constitution as amended. He contended that the defendant failed to completely comply with the provisions of the law governing his appointment. The defendants, on their part, argued that the appointment of the claimant was terminated in accordance with the condition of service. The law is notorious that where an employee is alleged of misconduct in an employment relationship of this nature, being one of higher status than mere master and servant relationship, generally the employer must acquaint him by issuing him a written notice or query stating specifically the allegation against him, give him a chance to defend himself, and invite him to make an appropriate representation or defense thereto, be given an opportunity to examine his accusers, if any, be allowed to call witnesses, if any, and to present documents, and documents to be used against him must equally be given to him before the date of the panel to enable him satisfactorily prepare for what he would meet at the panel or the disciplinary committee. See the case of Benin Electricity Distribution Company Limited versus AC Aluka. Citation is provided. It is clear that the employment relationship between the claimant and the defendant is governed by Kogi State University Condition and Scheme of Service for Senior Staff 2008, which among other things regulate the appointment, promotion, dismissal, and disciplinary measures against the employees of the first defendant. It is plain on the claimant's letter of termination that the reason for the termination of his employment is by paragraph 4 of the letter. It's based on section 6.2.3, paragraphs 1, 4, and 8 of the condition of service. Clause 6.1 defines the misconduct to mean any act prejudicial to good discipline and proper administration of the university, while clause 6.2.3, under which claimant was sacked, has a long list of offenses that constitute gross misconduct. The first is gross insubordination. Subparagraph 4 are offenses of stealing, corruption, dishonesty, or fraud, sabotage against the university. These are all the allegations levied against the claimant, consequent upon which his employment was terminated. The first question that requires an answer is, did the defendant follow the procedure specified in the Kogi State University Condition and Scheme of Service 2008? Clause 6.3, it as the disciplinary measure provides those, and I quote, any staff who engages himself or herself in any act of misconduct as stated in 6.2.1 above shall be disciplined in any or a combination of the following: A, query, written warning after 3 queries, withholding of increment, suspension, D, demotion, deferment of promotion, termination, dismissal, and finally, making good the loss or damage to the university property. Disciplinary procedure is provided under clause 6.4, and it states thus: the procedure for effecting disciplinary measures is as follows. 6.4.1, queries. Staff shall normally be queried in writing, and if his reply is unacceptable, then the head of department shall forward it together with his own recommendation to the registrar, who shall take further appropriate action, unquote. 6.4.3 provides for suspension, and it states, I quote, if in the opinion of the Vice Chancellor an act of misconduct has been committed, which is of serious nature to warrant a drastic punishment, the staff shall be suspended from duty by the Vice Chancellor on half pay for a period of not more than 6 months. During the period of suspension, the staff shall be summoned before the Senior Staff Disciplinary Committee as provided for by the law. While on suspension, staff shall not be allowed to leave the service of the university until the determination of a case. And finally, a staff who is suspended shall not carry out his duties or visit his place of work except with the express written permission of the registrar. He shall hand over all university property in his possession to the head of department, unquote. 6.4.6 provides for termination. The appointment of a staff may be terminated on the recommendation of the disciplinary committee of an act of gross misconduct. And finally, clause 6.7 is the appeal, which has already been captured herein before. Having captured the above procedure, it is noteworthy that the key step to be taken by the defendant before terminating the claimant's appointment on the allegation of misconduct is the issuance of a query to him and also affording him an opportunity to make representation in person on the matter to the SSDC, who will send its recommendation to the council. As reiterated, all these processes enunciated by the above rules are to ensure fair hearing in the disciplinary procedure of its officers. As stated supra, where an employment is protected by statute, the process of removal, suspension, termination, or dismissal or retirement must be in compliance with the extant statute governing the employment, and the breach of any provision renders the process of such removal, suspension, termination, or dismissal void and of no effect. See the case of Obiawuna versus NEPA citation provided. From the record before the court, the claimant by Exhibit D8, dated 22nd of February 2015, made a statement at the Security Department of the first defendant. He was issued a query dated 10th of September 2018, vid Exhibit C5 by the first defendant, signed under the hand of a deputy registrar, establishment for registrar, on the grounds that he assaulted one Ms. Solomon Maria Omatere, a 400 level student in the Department of Political Science. He responded by a letter dated 17th of September 2018, that is Exhibit C6 to the said query. He was then given a letter of suspension dated 29th of October 2018, vid Exhibit C7, and placed on half salary in accordance with the extant law guiding the first defendant. Thereafter, he was invited to appear before the Senior Staff Disciplinary Committee, vid a letter dated 7 December 2018. His appointment was terminated by the first defendant with effect from Monday, the 13th December, by a letter by Exhibit C9. The minutes of the Senior Staff Disciplinary Committee before the court shows what transpired at the SSDC meeting. It shows that the claimant was afforded an opportunity to make representation. Claimant has equally admitted to due compliance with the procedure leading to the termination of his appointment. This is in view of his averment at paragraph 14 to 23 of his statement of fact. He did not say at any stage of his testimony how his employment was unlawfully terminated. All is stated at paragraph 29, 30, and 31 of his pleadings is that there was no petition against him, that the first defendant so motu initiated the disciplinary proceedings, and that he did not get the outcome of the SSDC. He, however, failed to evince on record that the disciplinary procedure leading to his sack was not followed. I found on record that the security unit of the first defendant received a report of assault of a said Solomon Maria, whom the claimant alleged was his fiancée. The testimonies of DW, one Joel Usman Amodu, deputy registrar of the first defendant, and that of DW2, one Major James Malik Adama, retired, the chief security coordinator of the first defendant, lent credence to the complaint made against the claimant respecting the assault on the said Maria Solomon, for which he was investigated and had to face a disciplinary committee of the first defendant. Claimant asserts that he has settled his cause with his alleged fiancée and in good relationship with her. I need to stress here that the issue between claimant and his alleged fiancée is not the issue before this court to consider. What is paramount to the court at this stage, in view of his claims before this court, is whether or not the first defendant complied with the provision of the terms of their contract in terminating his employment. The claimant has failed to demonstrate to the court that the first defendant did not comply with the procedure leading to the termination of his employment. He could not substantiate his assertion that he was supposed to be given a copy of the outcome of the SSDC. There is no such requirement in his contract. It is apparently seen on record that the first defendant did communicate the outcome of the disciplinary proceeding to him, vid the letter of termination, wherein the outcome of the SSDC was stipulated. He has failed also to convince the court that his employment still subsists. It is in the light of the above that I find and hold that the defendants have followed due procedure stipulated in its condition of employment and equally complied with Section 36 of the Constitution as amended. He has thus failed to prove his assertions. Consequently, I find and hold that claimant release 1, 2, and 3 fail. The claimant by release 4, 5, 6, 7, and 8 is praying for an order setting aside the decision of the defendants as contained in its letter dated 19 December 2018 to reinstate him to his office and position as lecturer 2 and the first defendant. Is urging the court to deem that he is already promoted to lecturer 1, is seeking for 1 million naira in damages. The law is long settled that you cannot place something on nothing and expect it to stand. It will definitely collapse. See the case of McFoy and United African Company Limited. Citation is provided. With respect to claimant's release 4 to 9, having held that the claimant's appointment was lawfully determined, it is obvious that all the consequential release will have to fail. It is in view of this that I find claimant's release 4 to 8 unproven and thus discountenanced. Accordingly, claimant release 4 to 8 fail. I so find and hold. The claimant also claims the sum of 200,000 naira for cost of this suit. It is the law that cost follows event, and it is usually granted at the discretion of the court, which discretion must be exercised judicially and judiciously. It is, however, well settled that a successful party is entitled to cost unless there is any enabling circumstance to deprive him. See the case of Okafor and Lemna Construction Company Limited and another citation provided. I find no reason why I should exercise my discretion in favor of the claimant by awarding costs in the circumstances of this case, having failed in all his claims. Accordingly, claimant's claim for costs also fails. I so find and hold. It is in the light of all the reasoning above that I find and hold that the claimant's claims fail in its entirety and liable to be dismissed. It is accordingly dismissed. No order as to cost, judgment is entered accordingly. Copies of judgment will be sent to you.
As the court pleases.
In Lokoja.
As court pleases, man.
As court pleases.
Well, we sincerely apologize. We joined late Amjiwa Jewale counsel for the defendant. We sincerely appreciate the honorable court for the erudite and painstaking judgment. We are grateful to the court.
My Lord, we sincerely wish to appreciate my Lord for the well-considered judgment, sir. We're most grateful.
Very well. So the court will now rise. Like I said, copies of the judgment will be forwarded to you in Lokoja.
As the court pleases.
All right.
We're grateful.
Thank you.
Congratulations, sir. And that's it.
We are all getting this one I can manage it. Yes. Thank you. So this is how we now to obtain the judgment.
Yes, sir.
Thank you very much.
Yes, sir.
That's very great.
You started.
It's very high suspense.
I was really. Which was.
And that has a very good tactics. Then I have to very.
Like weather.
Yeah.